going to go ahead and get started if everybody's ready. I have one of these wireless mics on, and the last time I tried it, I was told that I was coming in loud and clear in another room. So I'll leave this on as a gesture to the webcasting folks, so that the sound gets out there. But if someone comes running in and said, "Please turn that off, you're disturbing the fifth floor," or something, I'll do that. My name is Ron Stout, and I'm delighted to be here to talk about a new passion of mine and a set of projects that I think are incredibly timely and exciting and satisfying in ways that I hope you'll share with me as we go forward. If I can make this work properly. The title is about access to justice and technology generally. The sub-theme is that the mission of universities and law schools within those universities of education, teaching, research, and then service, that three-part sort of cluster of missions, can be incredibly well served in a very reinforcing way by a set of projects that I think are timely, available, and are sort of calling out for the kinds of approaches, intellectual approaches that you have, that you know, and the contribution that you can make is just sort of waiting there for you. In 1995, at the AALS annual meeting, and I think it was in San Diego, if I'm not, I get the places mixed up after a while. I was lucky enough to be part of a planning team that put together the first all-day workshop on teaching technology and law. And I think of that in terms of a lot of things that I've had a good fortune to be involved with over the years since 1978, technology and law. It's sort of a watershed event, because the ALS is not the most aggressive and radical organizations. They sort of reluctantly, with a lot of pressure from Peter Martin and others, agreed to put on this workshop. We had a long year of planning. They didn't think it would draw very many people, and it was oversubscribed by 200 people or 750 people that were registered. There were 150 people outside the door. And one of the first speakers was Bob Baring of Berkeley. And Bob got up, and I think he didn't quite put this up, but he put something pretty close to that up. He certainly put up the words "change or die," and said that should be on your bumper sticker. Right? Put "change or die" on your bumper sticker, because that's where we are as a teaching profession. We have to change, and the theme then was about, and the thing I talked about was electronic casebooks. That we're going to completely overrun all of our law schools. We're going to get rid of backpacks, and everybody's going to have computers instead of casebooks, and so on and so forth. And Dan Dabney just did a great presentation on some of the reasons why that hasn't completely happened yet. And maybe it will at some point, maybe it won't, but because paper has its advantages. But this is the kind of rhetoric since 1994 that's beginning to blossom. Just a few years ago, 2 years ago, in Arizona, 100 so-called leaders of the United States Bar were invited to come at the request of the American Bar Association to a Seize the Future workshop. And the purpose of that meeting was somewhat similar to the purpose that Bob Baring had in 1995 with law professors. It was to get these leaders in a room and bring some very high-priced talent, some very popular and expensive speakers, people like Tom Peters, people like Gary Hamel, who are Harvard MBA business gurus who write multi-million dollar books about how to change your businesses and so on. And the theme of that was really change or die too. And these guys stood up in front of all these lawyers and said that change comes from the outside. And the examples in business are where you start with Apple producing a PC revolution, not IBM, or Microsoft, not IBM. You talk about Netscape not Microsoft. You talk about eBay, not Merrill Lynch. You talk about Amazon, not Barnes & Noble. And say, out from the outside comes the energy, the enthusiasm, the perspectives that can help people make significant radical change in this context. Part of the reason they say that's needed is because it's not getting new ideas that's the problem. Even us old dogs can come up with new ideas. The problem is getting the old ideas out. And the way you do that is create diversity. You bring a variety of perspectives. And the diversity they talked about had a lot to do with youth. We're looking at senior partners in major law firms and corporate law departments and heads of bar associations and people like that in the room. And their advice was, you got to have youth in this movement, in this change or die reaction. That you have to find people and hire them who have extravagant, creative, aggressive failures on their resumes. If you have these sort of stately resumes that show a progression of successes right in the middle of the path, you're not going to get anything new or creative or powerful out of that kind of a person. Get somebody who's a creative outlier, who's willing to put on the resume that they started this business and they went up in flames. The bottom line was something that this group just couldn't handle. And that's pretty much a direct quote from what they suggested that the law firms do. Hire some people with green hair, whose bodies are pierced in a lot of obvious spots. Hand over the assets of the firm. Right? Mark, you've been involved in this. Hand over the assets of the firm and tell them that their job is to eat your lunch, to destroy you. Right? And obviously, the notion was, and think of the timing of this. This is March of 1999, right before all the bad stuff started to happen in the dot-com world. The idea was that you would take some stock in their enterprise, and as they destroyed you, you would own them. That set of opportunities, I think, is a bit of it's hyperbolic to think that all mature industries and professions need that kind of approach. But as I began to think about that approach to the law business, I thought about it as an approach to a period of time I spent in business on leave from my teaching responsibilities at Lexis, and where that business fit in this sort of pantheon of electronic change and evolution and revolution. And as I began to think about our work in teaching and research in legal education, and to think about the movement in justice systems generally, the e-filing movement that's about to break over, certainly all the federal systems in the United States, and more slowly because of the more significant administrative or political barriers over the state systems as well. It occurred to me that the kind of opportunity that was available in a law school was particularly well suited to meet this challenge from Tom Peters and Gary Hamill and Jack Landry and the others. But I started to think we ought to value our youth. One of the people at the 1999 session in Arizona, his name was Steve Gallagher, who's the executive director of the New York Bar Association, stood up after this series of things, and his indictment of us was, tomorrow, this was again 1999, New York will swear in 9,000 new lawyers who have an average debt of $70,000 and who can't do anything. Well, that was, I had to get up after that and say, no, you mean they can't do anything? Come on. We give them some tools, they do some things. We ought to see what they're like when they come in to the legal education process. In terms of not being able to do anything, they can't even think like a lawyer then. Hoots, Howells, Carl Biggio, and others just sort of booed me off. It was just ridiculous. I mean, there's no accounting for this. But if you thought about what the gurus were saying, they were saying that we have this. Maybe we don't have creative outliers with green hair and pierced bodies, although we have some of those. But we do have youth, right, in our classrooms, and we do have opportunities in the diversity that we're beginning to build on our faculties and in our student bodies to begin to handle some of these challenges. And it seems to me that judges are facing these challenges, that moderate and low-income clients, Bill Paul set up a project when he was president of the Bar Association. How do you make the E-Trade, Amazon.com thing work for all the middle-income and lower middle-income clients, right, who are trying to find those lawyers who make $45,000 a year, and vice versa, in a market that's more efficient and makes opportunity happen. Right? And bar associations are sort of standing in the way of that problem rather than solving that problem. Unrepresented litigants is a theme that I'll talk about in a minute. That there is an enormous upsurge in the number of people who are trying to navigate our legal system, including all of the parts of it that require litigation by themselves. And the numbers are staggering. I have a couple of the statistics, but it's like, I don't have it right in front of me now, but maybe 90% of the divorces in Arizona, 80-some% of the divorces in California, one or both of the parties are unrepresented. Up to half, both of them are unrepresented. Huge number, millions of cases. And judges hate them, clerks hate them, because the people can't navigate the systems that they use. Law professors, law librarians, and law students is sort of is the same set of issues that are being faced. And the kinds of things I'm thinking about here are the solutions that have been suggested by the gurus. Right? There's solutions that are web-centered, that allow us to personalize information and create sort of markets of one, or segments of one. They're innovative, creative, diverse, young kinds of approaches to the problems. There are problems involving multimedia, and in this sort of heaven of multimedia education that we're in today. I mean, it's just, you get a little bit of a vision about what might be possible. And it's a set of solutions involving mobile and ubiquitous computing, handheld, wireless computing, everywhere available, pervasive through society, Internet 2 coming, massive bandwidth on the way. All those things, all those solutions, and all those challenges are being faced by the same sets of people that the Bar Association is trying to address, that judges and clerks are trying to deal with, that lawyers are facing in their middle-income practices, and to some extent in the high-end practices, although they're pretty well served by consultants and support. And all of it's about human information and computer interface. It's all in that space someplace. So, what can be done about some of these things? This is sort of a cluster of organizations. And what I hope to share with you is a sense of opportunity that we may have to sort of pull together this set of challenges into opportunities for students to learn, for us to do good things with computers and internet tools and technology for students and for the people that need justice and access to justice in our society. About 2 years ago, we launched a project with a modest amount of grant funds with the National Center for State Courts, aimed at creating a community on the web for judges. And the idea of the project, with the $100,000 that was matched by another $100,000, was to establish a public website that would attract state and local court judges primarily, and then a private subscription-only area where judges could go as if they were at a judicial conference and ask each other questions about things and interact with one another in an open way without worrying that their political future was at risk, or that the press was there, or that a litigant was going to hear and be involved with, that they were involved with the complaining about their interaction. We also looked at some, part of the grant was to look at XML standards, and the National Center for State Courts handled that piece. And the third thing was to begin to experiment with using the web as a place to both gather information about access to justice for people without lawyers, but also to begin to think of it as an environment within which solutions for their problems might be actually posted, set up, implemented, launched, tested, vetted, and then shared. With these two projects, the Access to Justice Project, which I'll talk about in a minute, and the Illinois Technology Center for Law and Public Interest, we're really beginning to make that happen. The Justice Web Collaboratory Judge Link project that I described a minute ago has these two general areas, one with news feeds, reflections, links, judicial organizations, and this judge discussion area and chat. A year ago, I was ready to give up on this project. It was one of my creative failures, I thought. We had probably 10% of those hits a year ago. You can see, just looking at the numbers, that there have been 75,000 hits in the 2.5 years since it's been open, but 18,000 hits in April. Right, so some things are happening recently. It's starting to take off now. 182 registered judge members after some significant work with judges. This is not an easy group to engage in the community. And you can work and work and work on putting up stuff, and you feel like you're in one of those places where the trees are falling in a forest and nobody's there, and it's just like, what am I doing? Why am I wasting this time? My sense is that its time is coming. And part of it is because of this project. Roger Warren, the president of the National Center for State Courts, began to sort through what he could do as the leader of the judges of the United States, absent the federal judges. And one of the things he found that his colleagues and he himself had been faced with as he was a judge in California for 20 years was the problem of pro se litigants. And the problem of pro se litigants, to some extent, fits in his category of problem-solving areas as a problem of access to justice, making courts accessible, a target that he's been working on for the last 3 or 4 years there. And these are some of the reasons why consumers, in the form of people seeking dispute resolution from courts, are not getting what they need. And the theories are that 80% of the legal needs of the United States public are unmet. When surveyed, they say that the reason is because the law is too complex and courts are too complex, that lawyers are too expensive and lawyers are needed, that they don't have a lawyer, that they distrust lawyers, and they don't really understand how to navigate through the process. Solving this problem is not easy. The numbers I told you about are just the sort of the scratching the surface of the problem. The lack of resources is a problem. Our multi-language culture, huge influx of Spanish-speaking citizens and residents of the United States, and a dozen other languages that have enough of a community and enough of a population to create a serious issue with respect to court clerks and courts in general. Time constraints, lack of technical know-how, these are some of the issues, but my sense is that all of the problem is here. I think you can solve all of those problems, you can get money, you can do things, but this is the problem. I'll give you an illustration of why that's such a problem. 4 years ago, the clerk of the Circuit Court of Cook County, which I think is either the largest or the second largest trial court in the world, certainly in the country, decided that it was time to begin moving into the 20th century, and she let a contract to Arthur Anderson for a conversion of their back office and the creation of an electronic filing interface so people could begin to file papers and find things in the court system using just sort of the standard kinds of automation tools that even law schools started to use. Peter Martin used to talk about them in 1985. when he would go to conferences and these offices and stuff. The presiding judge of the Circuit Court of Cook County, how exactly, the legal procedure experts in the room will have a field day with it. He entered an injunction against the clerk, forbidding her to proceeding with this contract, and then created a committee, right, to study whether it was a good idea or not. Now, Cook County is a Democratic stronghold. We can all remember the dailies. The clerk's father was a longtime Democratic politician named Kuczynski. The clerk started out as a Democratic politician and changed parties, so she became a Republican. Right? So the idea that this Republican clerk was going to automate the Circuit Court of Cook County and her 9,000 or 850 or whatever, 1,000 patronage employees, right, in this huge multi-million-dollar contract, just galled Donald O'Connell. So he enters this injunction. Well, that's maybe an aggressive example of the kind of conflict that goes on. But when O'Connell's CIO meets with us in some of the projects that we're dealing with, he says, I have 182 separately elected officials who I serve, because every judge is separately elected. There are 182 judges in the Circuit Court of Cook County. And the clerk is separately elected, the sheriff is separately elected. Right? There was a notion at one time, I can't remember the exact numbers, but there were 192 different case management database systems in California alone, because every clerk had a brother-in-law that knew DBase 2, all right, who put up a database. And, a case management database is brain dead easy, right? What could be in it, right? The name of the case, the name of the parties, the date, the kind of case it is, and you can think how to do it, can't you? Also, and all these brothers-in-law, right, and sisters-in-law. That's the problem. To solve this problem, to be able to address this problem, the only place that you can go and get sort of a national perspective is the National Center for State Courts. And Roger Warren in that role is very important. He was able, with other help, to get the State Justice Institute, the Open Societies Institute, George Soros' foundation, the Center for Access to the Courts Through Technology, which is a lovely little foundation in California, run by a law professor named Clark Kelso, whose father many of you know, who's been a long-time law professor, started at the University of Illinois, went to McGeorge, and Clark is now at McGeorge. And Clark is just a marvelously creative law professor. I called him up this past summer at one point, for example, to check on one part of this project, and the secretary referred me to another number, and the number was answered by somebody who said the California Department of Insurance director. So he was serving as the director of the California Department of Insurance for 3 months, because they had a little gap. And the guy is amazing. Well, one of the things that happened was, in all his work with the courts and technology and so on, was that there was a class action that had a residue. And they have a cypre kind of statute in California, so they had $750,000 that they dumped into this foundation. That is the California Center for Access to Courts Through Technology. The National Center for State Courts and a matching fund at Chicago Kent. And out of this, we pulled together $689,000 to work the following problem with the following project partners: the Chicago College of Law, the Institute of Design, and the National Center for State Courts. We know what the law school is. The Institute of Design is the only PhD granting design college in the United States, I think. But it's a big design place, right? Big means they have 80 students. They come from all over the world. The ones working on our project came from 10 different countries. Some of them had green hair. Some of them had body piercings that they didn't show us. They spoke a lot of different languages. They had a lot of different perspectives. They had engineering degrees. They had architectural degrees. They had fine arts degrees. They had degrees in science and in the humanities. They have developed a process for solving problems that has been used by Motorola to design, actually it used to be a much better example than it has been lately, to design electronic handheld devices, by Kohler, the world's leading manufacturer of toilets, right? By Steelcase, they have a whole floor that Steelcase funds to design office furniture and modular furniture and office structures. By the national parks to figure out how to reuse or restructure, redesign the way we use the national park system. By the museum campus in the city of Chicago to figure out how people interact with the museums. By the Chicago Symphony Orchestra to figure out how people might better interact with the symphony orchestra and so on. The project was a threefold project, and the idea was to take these design experts and to mix them with lawyers and law students and address the problem of unrepresented litigants in the United States. To solve the problem from a brand new perspective. The three phases, and we're in phase 3 right now. The first phase was to identify the major barriers to access to justice by litigants without lawyers. The second was to employ the latest in system design methodology, which is the Institute of Design's approach, to redesign the process from the ground up. And the third was to translate these redesigned concepts into an internet-based prototype. And this is what I spent most of this academic year on. I did my teaching and so on and stuff you have to do. But this was the fun of the year. This was it was a joy. How did we identify the major barriers of access to justice by litigants? Well, the methodology by the Institute of Design is called ethnographic research. It's not surveys, it's not focus groups, it is go be the customer. And so we had 5 court partners identified by the National Center of State Courts, and we took teams of law students and design students out to these 5 locations. And we followed pro se litigants around and saw what they did. We sat for a day, 8, 9, 10 hours in the clerk's office vestibule or off in the corner. Just saw where people went and what they did. We interviewed pro se litigants standing and milling around outside the courtroom before the call. What are you here for? What are you doing? Why do you come? What do you want out of this? We followed them in, saw what happened in the courtroom, and then came out and interviewed them afterwards. Hundreds of hours of audio tape. I sat on the bench with a small claims judge for a half a day because he said you can't really understand this process from sitting from the side or the corners. You have to sit up here with me and see their faces and see what, you know. And he was right. It was very different up there. It was extraordinary. These are the 5 places that we went. These are the kinds of people that we had working with us. In phase 2, everything changed. Although we did another ethnographic research cycle. We went out to all these sites again because we had some different people on these teams. But it went from having a bunch of law students with a scattering of these design professionals to help us understand the methodology to having a whole bunch of design students and a scattering of law professionals. And the purpose of the law professional there was to be a domain expert. Right? This was all about design now. Theoretically, we've begun to gather up the problems, understand what was going on. And now the designers, the people who are trying to understand what the customer's interaction ought to be with the system and to define the system, went through a very structured process, and it would take an hour to explain the process to you if I understood it. And I basically was a domain expert, and I didn't have to. There was another professor named Charles Owen who invented this process, who managed the week-by-week progression through the thing. But we had 18 master's candidates and 4 law students and the researchers. We went back to the places again. And out of this comes a 500-600 page book. And the book describes 53 system elements. I had no idea what they'd actually do with this problem, right? What they do is they go out and design products that mesh together in some kind of a system that address the needs of the customer from the customer's perspective. And so they start out saying, well, you need something like a story builder. Right? These people don't know what to say or how to get their story out. So you need some way for them to interact with them. And the whole idea was to come up with internet prototypes. You need something that helps them understand the costs of pursuing any legal remedy. And I sat in the waiting area in a courtroom, and I saw a woman pursue a $25 case, right, for like 25 minutes of trial time. And the 50 people waiting to have their trial started to take up a collection. They said, well, give me the 25 bucks. No. But one of the reasons she pursued it was because it involved the babysitting setting, and she thought this babysitter wasn't as gentle or kind to her. It wouldn't injure the child. The child was sick, and she would call her. But she thought she was going to get the time off from work payment, lost wages, of the witness that she brought with her. Right? She said, well, Judge, the judge didn't want to hear the witness. Right? No, the witness doesn't have anything relevant to say. They determined what the witness was going to say. So the witness wasn't even called. But she thought that when the witness called, that she was going to get, $350 or $100 or whatever. She was going to get the time off from work from her to come in there, the cost of doing it. I mean, people don't know. They don't understand. The center of this sort of e-mediation theme out of the 53 system elements is a process that I'll try to sketch out for you a little bit. But part of the idea of this structure was to pull out from the 53 some themes that their approach was to take the whole system and write a 53-element requirements document. When I was at Lexis, that's what this would be called, a requirements document. Some project manager will go out and say, what you need, right, is an electronic treatise. Right? And so what does an electronic treatise have to have? Dan has experience with this. Well, people in business, you write these requirements documents. What's that?
This little 325?
Yeah.
That's a requirements document.
I don't know what this is. We'll get to that later. Thank you. Maybe it's for the next session. A requirements document is a story about what the customer interaction with your product is and how it works, basically. The customer will come in and turn it on, and then the first thing they'll see is this, and then it has to have these things in it. It has to have all the statutes in it. It has to be able to navigate from here. It's got to be in color. It's got to be, right? So this turned out to be a requirements document. The reason I began thinking of it that way is because we had a conference last week, 10 days ago at Chicago Kent, called the Judicial Decision Support Systems Conference. It came after the AI and Law Conference in St. Louis. And Carl Branting and these AI and law experts came there, and I was explaining this project to them and saying, "What, Ron, you've done this. Your team has created a great requirements document for us because we do the black boxes. We know how to do the AI pieces that hang inside this requirements document." Right? And the starred items were items that at the JDSS conference we decided included. Want them back?
Yes.
Well, you're getting the better reaction than I am. Would you come back in about 10 minutes and then bring me some else?
Okay.
Okay, thanks.
Need coffee or tea?
All right. These started elements appear to be the places where you need some artificial intelligence kit. Now, the interesting thing is the design people, they don't care what you need to make this happen, right? They look at it from the customer's perspective. They just say, this is what people coming to the courts have to have in order for this thing to work right. And I'm looking at it and saying, you can't do that. We've been trying for 25 years to figure out how to diagnose a legal problem from an undifferentiated kind of story that somebody taught. You can't do that. I mean, you can't just say it's going to happen there. He says, yeah, we can. We just write it in here. You've got to have it. Now, the key thing of this is that it doesn't have to be all automated, right? They're one key feature of the design factors for this system is that at any point you can step out and get a person to perform the function. So part of the process will be, as you go through and try to build these things, well, where does the person come in and how do you get the person and so on and so forth. Let me go back to that one more thing. There were a whole series of these system elements that I pulled up in another theme, which I believe can be organized around the following set of insights. Now again, think about it. These are non-lawyer professionals going out looking at our core process and saying these are the things that are needed. All these things on the right appear to me to be the kinds of second-order tools that people are going to have to build anyway as soon as e-filing gets put in place. Right? The e-filing movement is pushing forward with momentum-driven. Actually, if you look at the West business case that they put on the web maybe 3 years ago, 2 or 3 years ago, it was up on the web. The business case is based on the fact that it costs, whatever it is, $45, right, to get a complaint and a summons from the lawyer's office to the clerk's office and to the places that it has to be served, and you keep multiplying that number out by every document that has to be served and everybody, and you get billions of dollars, right? And then you look at from the court perspective, and you say, I have to have 75 people who push carts around with files on them to go to the various courtrooms and so on and so forth. And the efficiency of just fixing that problem, that paper problem, is driving e-filing. It's about almost all of it. And everything else so far on the e-filing side has been, oh my God, once we put all the divorces in an e-filing system, somebody can sit at their home computer or their home web TV and find out the grounds for divorce for their neighbor. Right? Well, that's a serious problem. Right? But it's not a solution. It doesn't push the solution side. And these are all sort of, what's the process going to be, and what's it have to look like to the customer when you're going to go try to get service from the sheriff and an e-filing system, and you work through all these various things. The third theme, almost everything else in these 53 elements, almost every other solution, was something that you or I, if we weren't lawyers, would say, well, that's just obvious. That's just this courteous, common customer service. Of course courts should have that. You know, like signs that can be read and information about when your case is coming up and about when it'll happen. And when you go study this system that we train people to enter from the outside, it is the most hostile customer-facing system I can imagine. I mean, it just totally disregards people. I mean, it just churns cases, man. That's all. It just cares about cases. And if you just say, let's just think I'm a person, I'm coming up. Have you ever tried to be a law clerk for a law firm in Illinois and go to the Circuit Court of Cook County with all these politically hired folks and just know where to file something, how much money to pay, and what form to use, and so on? You know, one of the things we're doing with our designers, we send them over there and say, go get the form that you need to file a divorce. Just go find it. See, how are you going to find it? And they come back appalled, right? And once you start moving things to electronic form, you can address a lot of those customer service needs very easily. This is the system map that the team this past semester finished up. And each of these little boxes are clusters of those solutions as you work through how a litigant comes into the system and can work through the various parts of it. So that's pretty cool, right? And then, just to blow up a piece of it, this gives you a sense of what it would be like. When you come through a thing, these are archetype identifiers and frequently asked questions. You just pursuit evaluator piece up there, up here, and then you come out of that and say, well, I decided to pursue trial or seek. And this is a seek help and return thing. This is to go out and find a person thing, right? And they broke up the whole system into diagnosis and logistics and the hearing itself and so on. It was a fascinating thing to do. If you get a chance, take a run at it. Here is the way the requirements document or the system description begins to describe one of the solution elements. This is the story builder. Its features are described. This thing, right, this solution, extracts facts from a set of direct questions posed to the user on one side of the screen, builds a flow of text by inserting facts into pre-written causes. The story on the other side provides an iterability to the users and so on and so forth. And these are the properties, and then they give a mock-up of a web implementation, what that might look like. Right? So this is what they thought a story builder might look like. That's a little busy to me, but that's not supposed to be done. E-mediation is the center of this one cluster of things, and here's the property for e-mediation. And a lot of this was driven, the theory about the e-mediation solution element was driven by some of the work that Ethan has been involved with, that David Johnson has been involved with out of virtual rooms, and things like CyberCell. And I looked at the web and all these things that are going on the web. And you'll recognize, if you know CyberCell, you'll recognize a little of the CyberCell theme here. But the idea is that you can come to some kind of interactive software that you can be shielded from one another. And some of that was driven by the domestic violence cases that they looked at. They didn't want people to be seeing each other in this thing. So you go to a web place and make this happen. That it would have a complete record, that it would have a forum for mediators, so you get live people mediators in the system, and so on and so forth. And it might look something like this. This is sort of a schematic process. They looked at divorce cases and said, well, let's figure out which of the 4 major issues we want to work through the e-mediation system. This is the one that they found most likely to succeed, which was an e-mediation on property and assets. The theory was that you would use the e-mediation system to separately list the assets of the marriage and then value them and then work through a process like CyberCell to pick the things that you wanted using the currency that you would have. And they had an interesting concept of laying emotional currency in the thing. Remember Owen Fiss's Discovery game? You know, how many of you do that? And he had this thing, I think it was called, you lose face points or prestige points. You could only object or make the motions to compel discovery so often until the judge got angry at you and said, I'm tired of hearing from you. It was an attempt to put a little verisimilitude into the game, because judges get that way. I mean, you can't make every objection without getting sort of screamed at eventually. But some of that was put into this process. And then if the self-mediation works and it comes out at the bottom, it gets sent to the judge, and if it doesn't, the things that aren't resolved remain in disputed categories, either go to another mediation or can go, and so on and so forth. So you get the idea of what the requirements document looks like. This is an order maker, which might fit in either of the 2 themes. But think about electronic filing. Who's thinking about what the judge should have in terms of creative web-based tools when all the elements of the judicial process are electronic? Who's thinking about that? And what should the interface be for these very senior, technology-resistant members of our profession? Right? Nobody's thinking about that. Now, some designer who's the son of the DBase programmer, right, that did the court management system, is going to put up some screen for the guy. He's not going to know anything about how it works. So order maker is another one of these processes. They had this notion that there always should be an assistant in the system, e-resolution assistant, and this is a live chat. You put the picture of the person there and then run a live chat. So at any point you can just punch a button and do a chat. They picked up from the NBC product the idea that you should be able to click on any word on the web screen anytime you interacted with the screen. Click on any word and get an explanation of what that word meant. Right? Well, that's sort of a neat idea too. Is it INBC that does that? Is that the right one? I mean, it's a new web interface. I think it's called INBC, and it was a very clever way to approach things. I think they're going under. That doesn't mean it's a bad idea, right? Where's all this going to go? Well, right now, we're in the 3rd phase. We've just hired a group called IIT Collaborative to go and build to build this theme, these 7 elements. These are the same people that build the website for Nike. I mean, it's a high-end commercial group that are cutting their rates dramatically because they have designers that come out of the Institute of Design. So they want a relationship with the Institute of Design to hire their best people. And so they're working with this project for that reason. And so I met with them the day before yesterday, and there were like 8 designers and website designers of various types around the table. And they'd spent the previous week trying to bang through this and figure out how would you write an e-mediation thing and how would you do that thing with the property and so on and so forth. And it's just a fascinating opportunity to interact with these people. So that group is being built out. The only one that will be built out and will actually function is the e-mediation piece, and the others will be mocked up. And the theory is that once that's done, that we go on the road with this product and show it to the 5 courts that worked with us at the beginning, and to see if they're ready and willing, as they said they probably would be, to try this. Right? We're going to probably build the first one as a landlord-tenant kind of e-mediation setting for unrepresented tenants, and another piece of it will be probably for that property aspect of the otherwise default uncontested divorce. Let me talk to you about a parallel project. 8 months ago, actually a year ago, the Illinois Lawyers Trust Fund, the IOLTA fund in Illinois, funded through Hank Parrott a study of the use of technology by Illinois legal services lawyers. The study proceeded, ended up with a big, thick book that indicated lots of need, a few little challenging ideas for solutions, and a proposal that an Illinois organization be created that would be a single portal on the web, contributed to and participated in by all the legal services organizations in the state, all the pro se support organizations in the state, all the pro bono and lawyer referral organizations in the state. And that one single place would take all that input, organize it on the web, and serve it back to the community in ways to gain some of the efficiencies that the gurus said that we have to gain for our population. Last December, the Bar Foundation of Chicago and the Illinois Lawyers Trust Fund committed $1 million over 3 years to build that site. In the moment they did that, the university matched it with another $1 million. So we have $2 million to build over the next 3 years the definitive site for those populations. We have a collaboration agreement in place with all the legal services funded legal aid organizations in the state. There are only 3. The Legal Aid Foundation of Metropolitan Chicago, Prairie State Legal Services, and Lincoln Legal Services cover the state. CARPOS, which is the countywide hotline in northern Illinois. Southern Illinois University is on the project, and there are 14 members. The Illinois Bar Foundation, the Illinois Bar Association, and so on, have signed a collaboration agreement. We've hired an executive director. John Mayer has taken a significant amount of time in the last 6 months and will, for the next 6 months, serve as the technology director for this organization. We've hired a content manager. We've entered into an agreement with the pro bono net people from New York to set a national standard for back-end database structures using SQL Server and Cold Fusion middleware, so that we can nationally build these statewide websites that can be organized across the country. The Legal Services Corporation last week began reviewing applications for $7.5 million in technology grants applied for by literally every state. Second time they've had these technology grants. They had, I think, $2.5 million last year and $7.5 million or $8 million this year. And part of it wasn't an exact requirement, but you weren't going to get any money, right, unless you addressed the needs of pro se people, and unless you showed that you were dealing with the problems of the state in a coordinated way, so you didn't have competing organizations trying to do the same thing and stepping on each other's toes. And one of the types of grants that you could get was a sort of a $50,000 grant that, like, anybody that applied for it's going to get, I think, to do a pro bono net SQL Server, Cold Fusion, kind of coordinated place just to provide knowledge management information. So what's the point of all this? The point of all this is that we are the people that know how to take advantage, that know how to implement, know how to think about applying technology to educating people who don't know anything about law, to teach them how to know something about law. So Steve Gallagher, the executive director of the New York State Bar Association, is wrong. It's part of what we care about. We care about delivering legal concepts in ways that can be digested by people who don't know anything about law. That's what we do in the first semester of law We are the people who have colleagues that are in clinical programs, and almost every law school has a clinical program that's doing legal services for folks, right? Who could begin to take all the work that we're doing to try to figure out how to make law teaching and law student education effective using these tools that apply exactly the same kinds of concepts and the same kinds of tools to the needs of the legal services community, and begin to solve the problems that are coming through the door there, and to extend the reach and the range of our clinical programs like you're doing at Nova and other people are doing in other places in the country. And out of it, I think, can come amazing research about the most important issues that we as a profession and lots of other professions are facing. Amazing research about how people interact with our legal system, how we can teach better, what the results are out of the interactions that we propose. And my sense is that it's all upside for us. It makes us so incredibly relevant, and it's such a powerful challenge that it's almost like, I mean, how can you not do it? Legal services money available in almost every state, organizations needing the help that we can provide, and people who can be immensely better served by we lawyers if we apply ourselves to this topic. So basically what I'm here to say is encourage you to find this set of opportunities in your institutions. Questions of any of this?
Is your stuff going to be available on CALI website on your presentation? Or
yeah,
it's available. Okay.
Actually, the Justice Web Collaboratory organization of Judge Link and the Access Project, the Illinois Technology Center for Law and Public Interest, IllinoisLegalAid.org, and so on. I mean, you can get to most of that through www.judgelink.org. Or you can get to it off the Chicago Kent site, which is www.kent.edu. So there's a lot of ways to get to this. I mean, the whole idea is to put this stuff up and make it available. And the whole process of the course is there. We have the students making presentations on these elements. We're all webcast and are available on websites. And Ken, if you wanted to spend like 4 or 5 days on this website looking at it, and Ken's waiting. He's like, no, I don't want to spend that much time. Just give me some. Other questions? Yes, sir.
The system you want to make available in the courts?
Yes.
Or in the law schools too?
Well, the Access to Justice project is aimed directly at courts, and the partners are 5 court systems.
Who's funding that? The court system or
the State Justice Institute put $150,000 into it. 2 foundations put another $300,000 into it, and then the Law School Matching Fund matched some of it as well. So the next round of funding for testing is probably, I mean, what I'm told is the best opportunity for testing is to get individual court systems to match a $50,000 application to the SJI, and then you get $100,000 to do a test for a month or 2 or 6 months or whatever you can squeeze out of that. So that's our next round of funding. Yes.
The legal aid portion, were you able to get like the state agencies in? Because it seems like that's a lot of the information bottlenecks for say people are dealing with state agencies, which can be difficult for
it's one of the things that you learn as you sort of wander through this, that is true. The answer is not very much, not in a formal way. Certainly in terms of understanding the requirements, if you pick something like public housing, right, then you got to deal with the Public Housing Authority in order to put a system up that will actually do the work, because that's part of the process of getting evicted from public housing is that the authority acts in some fashion. And so there are a lot of, and the legal aid group, the legalaid.org has identified 3 targets for its initial year of web building, and that is family law, landlord-tenant, and public benefits. And so all the public benefits stuff is about agencies of that type. But when you get into juvenile stuff and you get into domestic violence, when all those areas trigger needs to understand how to deal with those other agencies. And none of these projects had an explicit requirement to do that. But you're right that that certainly is part of the structure. Yes.
Please don't misunderstand me when I say this, because I think...
Is this going to be a criticism?
No. It's going to be a comment.
Okay.
The comment is this, that I think what you're doing is absolutely wonderful. However, as a former county law librarian and somebody who's been working in the trenches for a long, long time with this, I would say that here again, we're going to see the, to use the cheap cliche term, the digital divide. We're going to have to deal in some way for some period of years with pro se clients who need an intervener of some kind. And that intervener, I have a hunch, is probably going to be the public law librarians and the public librarians. And I've had some experience with public librarians being able to take over some projects and work with them. And so I think we should not lose sight of these people, basically because, they're among the most vulnerable for reasons that one of which you mentioned, which was the language barrier, but also a barrier of literacy, of level of intelligence, and so on. They're going to need help. And I think in all these plans, we have to, I think, for the immediate future and for some time after that, I think we have to plan who really are going to be able to help these people. And shouldn't we be giving some thought to how do we train the interveners? We should be making sure that people like public librarians and the public law librarians really know about this stuff from the get-go and have a buy-in, because we're the people who are going to have to, I'm putting myself back now in the county law library world, we're the people who are going to have to deal with the actual client. And we have to make sure that this, which is great, we have to make sure that this is reality, that actually they can use the system, and they're going to need our help. And therefore, we have to understand it. So
that's the best criticism anybody's ever done in any work I did. That was that was it. Marianne, I agree with everything that you said, and you're right on target.
There's a component there that seems to be a little bit missing, and we've really got to try to get that in.
I mean, in an hour, you skim across the top of a lot of things, but and you're exactly right. And I can relate to this experience because I saw so many county librarians with basically helping people figure out, putting them to the right, giving them the right packet, and so on and so forth. It's a critical part of the system. The first answer to it is that from the student's design perspective, the idea is there's people that are all over the place. You've just gone to implementation and said, boy, when we implement whatever system that you test, you got to deal with this problem. The only thing I want to address a little bit is the digital divide thing, right? And this comes up all the time whenever you talk about this. Well, poor people don't have web, so and so forth. But there's two answers to that. Answer number one is the answer that the futurist gives, or that the people that are talking. They say, as the technology becomes like television, right? Then all poor people will have it, because most, not all, but a huge percentage of poor people have television. And so as this becomes the television of our entertainment of our society, then the bandwidth will be there and they'll get into their homes and so on. But that isn't really the point at this stage, to me. The point is it's almost like, so what? Where do the people go now? Right? Well, they go to these places where they're treated badly and they don't have adequate services, and they don't have adequate information. And to the extent that some of them, right, at that spot can be shown the opportunity while they wait 6 hours or 4 hours to see somebody to help them, to go over here and go to a web-based terminal and use it to learn about what they need to do or get ready for the conversation or whatever. We have an advice desk on the 6th floor of the Daly Center in the Cook County Circuit Court, run by a young law student, former student of mine, named Brennan Holmes. Brennan sees 6,000 pro se landlord-tenant defense cases a year. People come in the morning, and whoever gets there first gets on the list, and they have to wait, right? And they literally will wait 5 or 6 hours to see this guy, right? And they're sitting around in this open, ugly space, and it's horrible. So, well, you could put 5 machines there, and some of them would be absolutely clueless as to what to do with it, and some wouldn't, right? And then the next step beyond that is to do exactly what you said, is that you have somebody helping people use that. So you're leveraging what slim personal resources that we have. With the technology that's becoming increasingly pervasive and available, at least in the public spaces, the legal aid offices, the clinical offices, The agency offices where people go to apply for things, they have computers in the background and access to the web.
And God forbid, the public libraries.
Well, the library is going to be the obvious because that's where we're getting, that's where Gore's systems are implemented, access to everything. This has been great. We're past time. Fill out your evaluations, and thank you very much.